Good morning, this is Public Defender Warren County from here. State your name, please.
Ramirez.
Thank you.
Now, we are here for a pretrial and there's also a bond violation.
Yes.
The reason being because he did not go to community corrections as ordered after his arraignment. I did speak with him about it and he stated that he was confused. He didn't realize he needed to go. He said that he was trying to pay attention to what Your Honor was saying. He was nervous. He heard the last thing that came out of your mouth, which was the next court date, and that's kind of all he remembered as his arraignment was finished. We did speak about the warrant. He did fill in the warrant recall. He did not put himself in because he's in school. He's at Washington Community College. But he is here. He does want to address the warrant today. He is willing to go test right now. And he believes he can come back clean. And he's asking for more to be recalled and another referral to be made to community corrections so he can get back.
Cancel the bench warrant that's out or reinstate previous bond. Defendant to report before he leaves this facility to community corrections for placement on a scram tether this time. So we don't have an issue. All right. And then I'll adjourn this out. How much time did you need?
I think the 18th should be okay, Your Honor.
I'll adjourn this to September 18th, 2024, 9 a.m. You understand that, sir?
Yes.
You need to get over to community correction. All right. Thank you.
Consider it G as alternate. Take the LHD with the 0.206.
Sir, if I give you a test that's going to detect alcohol, whether or not you consumed alcohol recently, are you going to pass that test?
I'm pretty sure.
Why aren't you absolutely sure, Mr. Allen?
Because I don't drink alcohol.
What do you mean you don't drink alcohol?
Well, stay away from anything that's gonna get me in trouble. I'm just trying to fix everything, you know. I'm just trying to get back in order, you know.
When's the last time you drank?
Probably like 2 years ago. Hey, somewhere right there.
Well, that can't be true.
Probably like. Well, I just haven't been drinking, you know. I don't drink anymore.
All right, I'm going to try this again. When was the last time you had something to drink?
Something to drink this morning. Coffee.
I mean, alcohol.
Oh, that's funny.
Okay, probably like 12 months ago, maybe. Somewhat. Can't remember, but you know, 12 months ago, let's say.
So you haven't consumed any alcohol for the last 12 months?
Probably mouthwash, you know.
Council approach. Okay, so here's what I'm going to do. Sir, I need straight answers to my questions. So I'm going to give counsel an opportunity to talk to you about how you address the court and answer the court's questions. So, Mr. Allen, if you could have him have a seat over here, and Ms. Parody will get to you as soon as possible, and we'll see where we go from here.
Assistant Public Defender Lauren Perry on behalf of Mr. Ramirez, who's been very kind for the record to state your name.
Name Ramirez.
I did have a chance to speak to my client. We did speak about the answers to your questions and how it's important to give straight answers. I think he's quite nervous, and I think that impacts his, demeanor here today. But again, I emphasize, that the court wants straight answers. Regarding his drinking, he does think that he's going to pass. He indicated he has not used any drugs, marijuana, or alcohol. He believes that, the last time he drank was around the time of this offense, and hasn't used anything since.
Is that right?
Yes.
Send him over. He's going to be put on a scram unit. I also want, you haven't used any drugs?
No, sir.
ETG, and I want a urine test also. So when he goes over, I want a one-time drug test. And then if he's positive for anything, it's going to continue weekly. And then also an ETG, and he's going to be placed on a scram tether.
Would you like him to come back after his test, or? Okay.
We'll catch up to him.
Okay.
Thank you.
Thank you.
Fine to continue at this time.
Thank you.
Okay, so the people versus Thomas Hornberger.
Echelon people.
Good morning, Your Honor. Robert Owen, with on behalf of Mr. Hornberger. Mr. Hornberger, can you please state your name?
My name is Thomas Warnberg.
Thank you, sir.
Your Honor, today's date and time set for pre-trial in this matter. After speaking with Mr. Hornberger, he has informed me that he wishes me to be removed from the case and be appointed new counsel.
What's the problem?
I just don't have a lot of confidence. It doesn't appear to me that he's optimistic or has enough confidence for me to feel comfortable.
I'm not sure what that means. Sometimes attorneys aren't very optimistic. Okay, all right. I mean, sometimes they're dealing with reality of what you might be up against. And so what you really want is an attorney that's gonna like give you the cold hard truth.
Yes, sir, I understand that.
Okay, you got me?
Yes, sir.
And I've known Mr. Ellman. I don't think you're going to do better, but
I don't know. I just feel like I'd rather have someone else.
well,
It's nothing personal. I mean, he's a
No.
nice guy, but I mean, he's a very
He
nice
is.
guy. We have a good rapport. We get along well. I just feel that he just doesn't seem to have enough. It's just not positive and confidence enough.
well, I got you, but you
I
don't,
do understand what you're saying.
no, I got you.
Your
Okay.
Honor, if I could put it on the record, just, I don't know if this makes things easier or not, I wouldn't object to being removed from the case. If Mr. Hornberger doesn't have faith in what I'm telling him, I have no objection, if that makes your decision easier.
No, but nice try. You don't get to pick your attorney because you're appointed on this.
Correct.
And so that's not how the choices are made. There has to be a basis upon which I would remove an attorney from a case, sir. That's not a sufficient basis that you've given me. All right. So what I'll do, Mr. Ellman, if you want to file a motion or do whatever, then you can. I'll adjourn it out for that to happen. But if that's the basis for it,
Could we pass the matter? I'll talk with Mr. Hornberger and figure out what he wants to do moving forward, and then if you could recall
fine, Mr. Ellman, I'll recall it. All right, I'll pass it so you two can chat a little bit,
it.
all
I
right?
appreciate it.
All right.
This courtroom hearing begins as a routine pretrial review, but it quickly reveals deeper issues of confusion, credibility, and accountability. The prosecution explains that the defendant is facing a bond violation because he failed to report to community corrections as ordered after his arraignment. According to the state, the defendant claims he was confused, nervous, and did not fully understand the court's instructions. He says the only thing he clearly remembers hearing was, "The next court date." The defense attorney attempts to provide context rather than excuses. She tells the judge that the defendant is currently enrolled in Washington Community College, did not intentionally ignore the court's order, and did not turn himself in on the warrant because of school obligations. Importantly, she emphasizes that he is now present in court, wants to address the warrant, and is willing to comply immediately, including submitting to alcohol testing and returning for further proceedings. The judge responds firmly but fairly. A bench warrant is recalled, but the court makes it clear that compliance will not be optional going forward. The defendant is ordered to report immediately to community corrections before leaving the building, where he will be placed on ASCRAM, alcohol monitoring tether. The matter is adjourned to September 18, 2024, with the judge confirming that the defendant understands the instructions clearly. At this point, the hearing takes a tense turn. The judge asks a direct and simple question. If tested for alcohol right now, will the defendant pass? The defendant hesitates. What follows is a series of inconsistent and confusing answers. He first says he is pretty sure he will pass, then claims he does not drink alcohol at all. When pressed, he states the last time he drank was 2 years ago, then says 12 months ago, then struggles to give a clear answer at all. When asked what he drank most recently, he awkwardly responds, "Coffee," which prompts visible frustration from the bench. The judge makes it clear that this courtroom requires straight answers, not vague or nervous guesses. Concerned about the defendant's credibility, the judge pauses the proceedings and allows defense counsel to speak privately with her client about how to properly answer the court's questions. After the brief consultation, defense counsel returns and clarifies that the defendant believes the last time he consumed alcohol was around the time of the original offense and that he has not used alcohol, marijuana, or other drugs since. She reiterates that nervousness may be affecting his demeanor, not dishonesty. The judge proceeds cautiously. The defendant is ordered to submit to an EG alcohol test, a urine drug screen, and placement on the SCRAM tether. The judge warns that if any test comes back positive, weekly testing will follow. The case then moves on. But the atmosphere remains serious. In a separate matter, another defendant requests to have his appointed attorney removed, claiming a lack of confidence and positivity. The judge responds with blunt honesty, explaining that court-appointed counsel are not chosen based on optimism, but on professionalism and realism. The judge makes it clear that defendants do not get to shop for attorneys simply because they dislike the legal advice they are receiving. The hearing closes with a clear message echoed throughout the session. Nervousness does not excuse confusion, and confusion does not excuse noncompliance. The court is willing to be patient, but only with honesty, accountability, and strict adherence to its orders. If you found this courtroom moment intense and eye-opening, make sure to like the video. It really helps the channel grow. Subscribe for more real courtroom stories, shocking hearings, and moments that reveal how justice truly works. And let us know in the comments, was the judge fair or too strict? Your opinion matters.